show, and we're starting off here with Lauren Frieder, attorney Lauren Frieder, that is, Frank Charles Miranda Law. Hey, Lauren.
Hey, Brandon. How are you?
Hey, I'm doing well. And yourself?
I'm doing great.
Hey, good to hear it. So there's a lot of stuff happening. I want to jump right into it because you've got some really cool updates for us. Things, happening not only, on the Florida side, Florida liability for damages related to COVID. What else are you seeing out there, Lauren?
Well, obviously, as you know, we're seeing a lot. And what's going on right now is, it's great to see people getting vaccinated. So one of the many questions that I've gotten from people, clients and non-clients, are, can employers require their employees to get vaccinated? And the short answer to that is actually yes.
Wow, interesting. Okay.
So that's going on. We've got the liability for damages Senate bill coming up. It's going to pass most likely on Thursday in the House, and it's a very sweeping legislation. It's going to protect a lot of business owners, physicians, healthcare providers, and nursing homes. And then, as you know, in the federal world, we've got our mortgage moratorium expiring the end of this month. But what about evictions again? So,
yeah,
Florida bills that have been proposed to help tenants out.
So what do you think is going to happen there? Well, so the mortgage moratorium, a lot of people are concerned, tenants and landlords alike. What do you think is going to partake there?
Well, that's a really great question because I'm always curious to hear other people's responses. I think that it could possibly be extended. I would be surprised if it wasn't. But if it does not, I think we are going to have a lot of foreclosures coming up very quickly. Maybe the market will be better for some of these people looking to buy, but I would say in the Tampa area, not to expect that. We are in a crazy market, so don't get excited about foreclosures coming to help this market.
Yeah, what a challenging time for all people, really. You look at the landlord-tenant situation, and landlords, they buy properties in an effort to potentially make a profit and rent them out, and then they got to pay their mortgage still, unless, of course, they paid cash for it. But, I imagine a lot of them have leveraged, what they call OPM, other people's money, to be a sophisticated buyer and an investor. So the landlords buy these properties, tenants are in place, COVID hits, and it's been, how long have they been in a position where they're not able to collect rents?
Well, in Florida you are, so you're fine unless your tenant has went ahead and filed that CDC guideline sworn affidavit under oath that they were affected by COVID-19, which was kind of halted stuff in that sense. But, for a while now, as we know, thank gosh, Florida's been open. So our evictions are going through seemingly. There are, two proposed bills because of what's happened, obviously, from the pandemic and the way our Florida statute reads, which is super easy if you want to do an eviction. But there's two proposed bills that have come up relating to evictions to try to help tenants. The first one is Senate Bill 926, and what that talks about is expunging your court record if you were evicted and can show that the eviction was directly caused from the impact of COVID-19. And I think that that's very important for renters to know that they might be able to get the scarlet letter E off of their background check, because landlords, of course, are always wanting to make sure that somebody timely pays their rent. And typically when you're evicted, that's going to stay on your credit for about 7 years. So that's nice. At the same token, I think they're from a landlord perspective that could kind of probably be abused. Maybe we would all want to know the full factors as to why you couldn't pay your rent during COVID-19 instead of it just being signed and sealed and nobody knows about it. The other Senate bill that has been proposed is Senate Bill 1090, and what that does, it removes the pay-to-play part of the statute that makes somebody as a tenant who wants to contest their eviction or fight it, they right now have to pay all of the rent into the court registry to even get into court. And that is really hard. It's a quick process. So you might have just lost all of your ability to even argue a wrongful eviction if you didn't have the money to get into the court registry. So that's kind of the pay-to-play part of the statute that we talk about that gives you access to courts to fight your eviction. In fairness, you should not have to pay to play to go to court. So I think that this bill might make a little bit more sense to me as an attorney that represents mostly landlords, though I think it could also make things go super long and stretch out evictions, which are pretty typically quick procedures.
Yeah, I agree with you on that. I mean, pay to play. I mean, people are already in a bad position as it comes if they've gotten evicted. So that to me just doesn't seem fair. And the purpose of law and order and justice is justice. I mean, that doesn't seem like it's a fair way to treat people. And again, it also with circumstances, relating to a pandemic, and a lot of this may not be their fault, as it might have just been more of a clear-cut case 5 or 10 years ago.
I agree. I mean, and in fairness, I definitely believe that there's probably just how it is, the pay to play as it is, even if we didn't have a pandemic, it's very kind of questionable, borderline. I'm surprised that it might still be in play today. So we'll see what happens. I'll be watching those Senate bills to see if they move on to the House. Those are newer. And the one we have discussed before, I think last time I was on your show, is the Senate Bill 72, which is the liability for damages relating to COVID. And that we know will pass.
Yeah. By the way, if you just joined us, we're talking with attorney Lauren Frieder here from Frank Charles Miranda Law, also a real estate law firm, and they do title closings as well as other types of litigation and law. By the way, what type of law do you practice, Lauren?
Well, we practice a lot of type of law, so a lot of civil litigation, which would encompass any type of specialty. So the specialty of civil litigation is going to court. Today you're seeing me via Zoom, which is almost now my courthouse for now.
Yeah.
So, but beyond that, real estate really is our big baby. So it's personal injury, commercial, and business issues. And really our goal is to try to keep you out of court. So if we can get to you ahead of time before any poor decision-making comes apart, then that is great. We're there to help you out.
Yeah, that's important. Sometimes people have hot heads and they fly off the handle and say, "Well, I'll call my attorney and I'll see you in court." It's always better to try to work it out amicably prior to going to that last resort.
Absolutely, it's expensive. It's a gamble. By the time you come to the courts, which is a last resort, or even go to the attorneys, then people are really upset once you get lawyers involved and the courts involved, and it's kind of out of your hands. So if you can work it out. Absolutely do. I always tell people to document every time they've tried to work something out, put it in writing, follow up. So if we had a phone conversation, then I'm going to send an email that says, per our phone conversation, Mr. Brandon Rhymes on March 23rd at whatever time it is, this is what we talked about. And that just keeps a paper trail. That way, if you do end up in court, it's going to make everybody's job a lot easier, including the fact finder, which is the judge or the jury.
Yeah, that's exactly right, and it's interesting you say that because we have with our Keller Williams company, the group that owns our offices. I think there's 3 different offices, maybe 4 now, but the group did $1.7 billion in real estate sales, and every year the owner has a meeting to that effect. It's basically, hey, how to avoid litigation, how to avoid some of these situations. But that's one of the key things that you take away from it every year is if you have a situation where there's a property issue and the buyer's frustrated or complaining about this, and then there's verbal, where to make that a short scenario is whenever you have a verbal, it's there's no backing to it. So if you have that email follow-up to that verbal conversation where the parties may have agreed or, hey, we're going to have our contract over there to double check it to make sure things happen, as long as it's in writing, it's really going to help you remember that because it's always going to be 6 or 8 months or a year later, and you're like, wait, I can barely remember what happened.
Yes, everything in writing is best. So obviously you're not required to put everything in writing, but for sure when we're talking about real estate, you are. So I think that's really important. Down to realtors right now, it's a hot market. So people that are working together, if you want to split commissions, put it in writing. Something lately I've seen people not doing, and then they come to us and they say, well, let's look at that paper trail of how you guys were performing before you came to me. So it's really important, like you said, put it all in writing if you can. Cheaper and easy.
So, Lauren, what else are you seeing on the COVID-19 front? Have you noticed mask mandates or any other issues with mask being worn or and that's also interesting that can employers require employees to get vaccinated? The answer is yes. That's pretty interesting too.
It's a short answer, of course. It's a very, very short answer. So when I say yes, obviously we're getting a great time where you can choose not to get vaccinated or not. But to let people know that our employers or employees, especially in Florida, because we are an at-will employment state, so we really, as employees, have less of an upper hand. So unless you're under contract or in a union, Florida employees have few rights, and you could be terminated for just about anything. And right now, that reason could include refusing a vaccine if the employer requires it. Like I said, there's always exceptions to the rules. So if an employee says, I don't want to get the vaccine for religious reasons, or they have a disability or a health concern, then you have to engage in what we call the interactive process to see if there's a reasonable alternative to that, such as wearing the mask or working from home remotely. So what's really important when I say short answer, yes, employers can mandate a COVID-19 vaccine as long as they comply with all of the equal employment opportunity laws. That's a lot of laws. So, I think the better idea is just to let people decide for themselves and then go ahead and put precautions in place for the people that didn't decide to get the vaccine. As you do have under OSHA, you have the right to require some employees to get the flu vaccine. So if the same happens for COVID-19, once it gains the final FDA approval, then under OSHA as well, you might have to be required to get the flu vaccine. And that can happen a lot of times in healthcare situations. But do I think that most employees are going to require this? Absolutely not.
Yeah. It just seems like a stretch. I mean, because you've always heard it too about getting on an airplane. That could be where people are saying, wow, I have to get a vaccine now that I don't agree with just to be able to fly. And then, the challenges that come around that. It's interesting how this thing can affect so many areas of life and business.
It really is. I'm very excited about the vaccine process, but I also know a lot of people that are hesitant towards it. So it's everybody's lives for the last year have been extremely affected one way or another by all this pandemic stuff. So it's exciting to get back to normalcy. We're lucky enough to be in the state of Florida where I feel like there's been a lot of normalcy over time, and we didn't see those surges that people predicted. So I think the Floridians, the residents, are doing a great job of just using common sense and showing that we don't need all these strict rules in place and mandates, which actually infringes upon our abilities to make independent and free decisions. So I think we're doing a great job here.
That's right. All right. Final thoughts here. Attorney Lauren Frieder, Frank Charles Miranda Law, right here in Tampa. Cypress Street is the address as well, right here in Tampa. Final thoughts, Lauren.
My final thoughts, Lauren, if you think you have a lawsuit for COVID-19, you better file it today because the rules are changing. And once this law does take place, which will probably be the end of this week, you've got a 1-year statute of limitations to bring that claim. It's almost impossible to bring against practitioners, businesses. The standard is so low to get your claim barred that good luck with that. So stay safe and make good decisions. If you think you have a lawsuit, file it now because those rules, once this passes, do not apply to already filed COVID-19 lawsuits. Thank gosh for those who filed them already.
Awesome. Well, hey, thanks so much, Lauren. We appreciate you reaching out. What's the website where people can find you?
Absolutely, Brandon. It is www.fcmlaw.com.
fcmlaw.com. Awesome. All right, Lauren, thanks so much. Have a good day.
Bye. Thanks so much, Brandon. Take care.
Hey, my pleasure. Take care. All right, coming up, Shane Socash, David Reynolds Jewelry and Coin. We're going to talk about investment alternatives, alternative investment options.